Hello, my name is Hae-Sun Kim, advisor of Gangnam Labor Law Firm. Today with Labor Attorney Jung Bong-soo, we will cover the important labor law application, whether it's a workplace with employees less than 5 or over. So could you explain about what is the important issue that we need to be very accurate regarding the workplace, whether it's below 5 or over 5 employees.
Yeah, okay. Okay, hello, how are you today? This is Bong-soo Jung, Korean labor attorney. Today I'd like to introduce what are application, the applications for those with the 5 workers or those conditions not applicable for those company that with less than 5. Yes, so today I received some verdict regarding termination case. So we successfully represented one language institute located in Gwacheon. So the employee who was fired due to her negligence. So we represent the company, so we knew. So employer fired the employee without a written notification. In document. So just verbally terminated. Then employee applied for remedy, and she claimed that company didn't follow the legal requirement for termination. So then we represented there are less than 5 workers, so this case should be dismissed. We explained, and a labor inspector asked many questions, also investigate this company, whether this company hired more than 5 or not. So I think regarding this termination case, number of workers that company hired ordinarily, that is very important. So what else we can apply to the company with less than 5? Well, those conditions that are exempt from application of this workplace, like those company with less than 5 workers cannot be applicable for this remedy application for dismissal. Also, they cannot ask for overtime pay. Also, they cannot ask for severance pay. Also, they cannot ask for suspension allowance during the shutdown period. Yeah. So these conditions are important. So even though those conditions they cannot be applicable, however, they protected some labor law the sections like some company with less than 5 intend to fire people, at least they must inform 30 days early notice or 30 days additional pay. Also, they cannot fire the people during the maternity, the maternity leave period. Also, they cannot fire people during the industrial accident compensation. The work-related accident, during treatment of work-related accident, they cannot fire. Also, employee, they should be entitled to for 30 minutes for every 4-day work. Also, 1 hour for every 8 hours. So they should take 1 day off, maybe 60 minutes or 1 hour off day for their work for over 8 hours. So also the maternity leave is valid. Also based on work-related accident, if they have a work-related injury, they'll be compensated by the government. Yeah. These are main the conditions they can be applicable. Also, there are not applicable cases. Yeah.
I see. So in case of severance pay, even the workplace less than 5, all employees should be paid severance pay? Is that right?
Yeah, yeah, of course. And the employee who hired the employee, maybe one employee or more, employee should pay their severance pay when employee resigned. So until 2010, company doesn't have to pay any additional pay for severance pay, but after year 2010, company should pay some severance pay to all workers, someone who served at least 1 year. Yeah.
I see. And when it comes to writing an employment contract, especially with foreign companies, they sometimes get confused with several terms and conditions. For example, like bonus payment, and confused about whether they should pay all the severance pay, statutory severance pay. So we need to explain clearly about the difference between the bonus and severance pay. Do you agree?
You mean?
Because they get confused about whether they should pay the severance pay for all workers.
Okay.
Because normally the foreign companies in the multinational company headquarters, they don't normally have severance pay, but rather pay bonus or incentives.
Yeah. So bonus is not, severance pay is not bonus, it is additional pay. So someone who served 1 year and resigned, then employee should pay as the name of the severance pay. This is statutory payment. It's not benefit at all. So actually it was introduced in 1965 when Koreans suffer from the poverty or no job. So they assigned the company, you should take care of those your workers. So severance pay started. Also they don't. Yes, something like that. Yeah. So those company with less than 5, they are applicable to the protection law limitedly. So I think it should be revised because there are so many people working in such a small size, and their protection wise should be accepted as a preferential duty.
And Korean labor law, as the time goes by, it's becoming more and more strong to protect every workers, whether it's less than 5 or more than 5. Do you agree?
Yeah. Gradually, the application of the labor law should be extended more to all workers. So, according to the Supreme Court, some Constitution Court of the labor of Korea explained the reason why the labor law is not applicable to the company with less than 5 is they considered some small size of the entities, so they are so poor they cannot stand by themselves. So to protect the poor companies, so I think it should be good to examine such a 5-day work week.
I see. So since it's sometimes the labor law changes and amend from time to time, I think it's very important for the labor attorneys to consult with the Gangnam Labor Law Reform Act, which is always updating those amendment of the applicable law.
Yeah, I think so. Okay, thank you for your comment.
Thank you very much for your comment.
Okay, thank you. Bye bye.